Of the bench, we have, as per from my left to my right, Justice Isabella Obara. Then we have Justice Dudley Ochiel. We have Justice Roslyn Odede. I am Ligunia Stephen, the presiding judge. Then we have Faith Olo, Justice Faith Olo. And we have Justice Herman Omiti, to my father's tribe. Welcome. The applicants, the floor is yours.
Second judge, video is right. I hope I'm audible. Revival of an economy, affordable housing, job creation, and debt avoidance cannot surely, honorable justices, be acceptable justifications for a state to breach both its national and international human rights obligations. Judge President, honorable justices, good morning and may it please this honorable court. My name is Simon Kimuhu Moreithi, appearing as the first counsel on behalf of the applicant, Kimetulik Human Rights Commission, alongside my co-counsel, Ms. Cynthia Jabet Yego. Of the 35 minutes graciously allocated to us by this honorable court, I intend to use the first 17 minutes to address the preliminary issues of jurisdiction and admissibility, as well as the merits of the first and fourth issue on the state's obligation to adhere to the principles of public finance and on the use of excessive force by the police. My co-counsel shall use the subsequent 16 minutes to address this court on the merits of the remaining two issues, on the state's obligation to protect and fulfill socio-economic rights, as well as the adherence to the data protection regulations. With the permission of the court, we humbly reserve 2 minutes for rebuttal. Unless directed otherwise, I'd like to proceed to a submission.
Please proceed.
Honorable Justices, Kimetulik is a developing country trying to maximize on its revenue collection in order to sustain its economy. However, the respondents in the enactment of the Finance Act 2023 disregarded the fundamental principles of public finance enshrined under Article 201 of the Constitution. This resulted in a rise in the cost of living, as well as deprivation of the socio-economic rights guaranteed under Article 43 of the Constitution. When the citizens tried to protest against this, what did they meet? Not a listening ear, but rather a clenched fist. People died while scores were injured, championing for their rights. All these occurrences, honorable justices, have necessitated the petitioner to implore this court to intervene and issue the requisite relief. With all that in mind, I would now like to delve into the preliminary issues.
Council, why do we have jurisdiction over this matter? Matters of taxes is a question of policy.
Yes.
They're made by your elected representatives. Why should we hear this case even if we have jurisdiction?
My Lord, to answer your question on jurisdiction, it is our submission that this court is vested with the requisite jurisdiction to address the issues before it, as Article 165 3D of the Constitution, as read with Article 23, grants the High Court jurisdiction to determine whether any action done under the authority of the Constitution or any law is in contravention with it, and to later on issue out the appropriate relief. Your Lordships, the matter before this court is a constitutional petition relating to the violation of fundamental constitutional provisions, and therefore this court has the jurisdiction to address it. Moving on. Yes.
Before you proceed further, is it your submission that we have jurisdiction over all the 4 prayers that are made?
Yes, indeed, my Lord, we have the court has jurisdiction over all the 4 issues.
Why would we deal with the issues such as data protection before us when I do not see any evidence that you exhausted any local remedies that exist?
My Lord, on the issue of admissibility, allow me to answer it in my next submission, that we acknowledge that the admissibility of the issues may be contested on the ground of exhaustion of administrative and quasi-judicial remedies. However, we seek to rely on the 2018 case of Mohammed Ali Badi versus the Attorney General, where the court at paragraph 93 stated that for a remedy to be exhausted, it must be effective and address the matter in its totality. We submit that the issues are interrelated and interconnected, and therefore they ought to be addressed holistically, as they all address the violation of human rights. And therefore we submit that these issues are admissible before this court. My Lord, I'm not quite conversant with the particular judgment, but I'd like to refer the court to the case of Republic versus Independent Electoral and Boundaries Commission and others, where the court stated that while the exceptions of the doctrine of exhaustion are not clearly delineated, the court, in determining this, shall undertake an extensive analysis of the facts. And if the matter involves a matter of public interest, the courts can oversee the doctrine of exhaustion. We submit that these issues are of public interest as they concern taxes that arise in the cost of living in the country of Kimetulik, and therefore this court should oversee the doctrine of exhaustion.
So, Counsel, just on that, on the 2 arguments, which one is your major argument? Is it that the remedies are not available, or that the issues are interrelated and therefore you need them to be addressed by these courts exhaustively?
My Lord, to answer your question, we do acknowledge the presence of administrative and quasi-judicial remedies to address some of the issues, including the data complaint mechanism for the data commissioner, the independent police oversight authority, but we submit that these issues are interrelated and interdependent, and therefore they ought to be addressed holistically as they all address the violation of human rights, my Lord. Moving on to our submissions, it is therefore our submission, my lords and ladies, that this court has jurisdiction and the issues are indeed admissible. Allow me to proceed to a substantive argument. Members of the bench, turning to the first issue, it is our submission that the respondent violated the principles of public finance in the enactment of the Finance Act 2023, leading to the imposition of excessive tax obligations on its citizens. We shall substantiate our assertions in 2 limbs. That first, the respondent failed to conduct public participation in the enactment of the Finance Act, and second, the respondent failed to ensure that the burden of taxation was shared fairly among all groups of taxpayers. Moving to the first limb on public participation, the Supreme Court in the 2017 case of British America Tobacco versus the Kenya Tobacco Control Alliance at paragraph 96 set out 3 fundamental elements of public participation. That 1, it must be real and not illusory. 2, it must be purposive and meaningful. And 3, it must be accompanied by reasonable notice and opportunity. On it being real and not illusory, the court stated that public participation should not be conducted as a mere formality to fulfill a constitutional requirement. There's need to have both quantitative and qualitative elements in the process. My Lord, while we acknowledge that Parliament is not bound by the views of the state bears the duty to encourage its citizens to participate in the enactment process by making use of as many fora as possible, including churches, mosques, temples, public barazas, national and vernacular radio stations, to disseminate information regarding the intended action, to ensure that there is sufficient consultation, as this piece of legislation, my lords and ladies, will critically have an impact in the cost of living of the citizens of Kimetuli.
Council, sorry, you're not very clear in responding to that question.
Yes, ma'am.
Is Parliament bound to take the views of public participation? And how does this sit with the fact that sovereign power belongs to the people? Thank you.
My lady, we acknowledge that Parliament is not bound by the views of the people. However, Parliament should consider these views as from Article 1 of the Constitution, the sovereign power belongs to the people, and it is therefore imperative for the Parliament to consider the views provided by its citizens in enacting such a piece of legislation. And also, to further answer your question, the National Assembly standing orders requires, in the consideration of a finance bill, the relevant committee in the enactment of the Finance Act should invite the views of the public while in the legislation process of the enactment of the Finance Act. Members of the bench, on public participation being purposive and meaningful, we acknowledge that, as was stated in the 2015 case of Mwiko Basin Local Community versus the Permanent Secretary Ministry of Energy, at paragraph 97, that inasmuch as the right to public participation does not mandate the state to take all the views as being dispositive, the state should take into account the different views expressed and ensure a high level of acceptance by those affected. Paragraph 19 of the facts paints the unfortunate picture, where despite over 90% of the Kimetulikans being opposed to the finance bill, senior government officials such as the Deputy President were heard in complete mockery of the people, stating that whether the people liked it or not, the finance bill would be passed.
Is it your position, therefore, given the fact sheet, that 90% actually expressed their disapproval?
My Lord, as seen under paragraph 19 of the facts, indeed 90% of the Kimetulikans were opposed to the finance bill.
Meaning, even the fact that they used the email to communicate was effective enough to reach 90%. Is that your position?
My Lord, as seen under paragraph 19 of the facts, this 90% statistics was from civil society organizations, and it was not from the public participation conducted by the state.
So the 90% is an opinion poll, or is it the people?
It is a report given by civil society organizations after they took the initiative to conduct public participation on the finance bill.
In which case, then we can't really say 90% of Kimetulikans properly are opposed to it.
My Lord, in the case of David Ndi versus the Attorney General and others, the court stated that public participation should ensure that the state works with the civil society organizations to ensure that public participation is conducted. And we therefore rely on the statistics provided by the civil society organizations to prove this. Further, in the facts, we see that the public participation conducted by the state was only through emails, and very few stakeholders gave their views on this public participation.
Council, that's a very interesting argument. You're saying,
yes,
you just cited a case and you're saying that the court has held that the government needs to work with civil society organizations.
Indeed,
you're saying that the government released an email and asked members of the public to give their views.
Yes.
You're saying that beyond that, the civil society organizations also give certain statistics and say that 90% are opposed. It means that they actually reached the 90% or more of the population. And so the two institutions were working together, and that is very substantial public participation.
My Lord, to clarify my statement, I meant that the government should work with in collaboration with these civil society organizations. But as seen under paragraph 19 of the Facts, they took the initiative on their own. The public participation conducted by the state, where the state really bears a duty to encourage its citizens to participate in the enactment process by conducting public participation, only took 140 submissions from stakeholders and did not involve a substantial number of the citizens in the process.
The fact sheet says 140 submissions from stakeholders, not that the government took 140. It means that they asked members of the public to give their submissions and 140 did.
Yes.
How do we blame the respondent for only 140 giving their submissions and yet they gave the platform?
My Lord, allow me to answer your question, moving on to my next submission, that public participation should be accompanied by reasonable notice and opportunity. This entails the public being afforded reasonable time to engage on the bill and give their views. We see from the fact sheet that the respondent only set aside 9 days and gave an email in a country where, from paragraph 4 of the fact sheet, we see that there's only a 35% internet penetration rate. My Lord, from this, there's no substantial number of citizens that were able to access the internet. And thus, these 9 days was very little to ensure that there was sufficient consultation on this piece of legislation.
Council, you have about 5 minutes. If you could address us also on your second head of argument.
It is therefore a submission that the state failed to ensure to the legal standards of public participation. Turning to the second link, your lordships, the petitioner submits that the state failed to ensure that the burden of taxation was shared fairly, which led to the discrimination against a particular category of taxpayers. Article 201 of the Constitution clearly provides that the burden of taxation shall be shared fairly to promote an equitable society. The petitioner acknowledges that the state may apply selective taxes to address different reasons such as distribution and equity. However, my lords and ladies, the state bears the duty to ensure that the burden is shared fairly to prevent the existence of favorites and sacrificial victims in the payment of taxes. The state failed to uphold this by imposing a mandatory 3% deduction from employees' salaries. We submit that this was discriminative as the informal income was left without any justification. Further, your lordships, a key reading of the fact shows that the Act seeks to amend the Income Tax Act by introducing a section that imposes minimum tax at the rate of 1% for a business gross turnover, regardless of whether the business is actually making profits or losses.
Councillor, am I understanding you to be saying your problem of the human rights is that the tax bracket wasn't wide enough? You have no problem with the tax, you're just saying if you're going to tax the ones who are employed, equally extend the bracket to ensure that you get 3% even from the informal sector. Would that be fair? And if we were to direct that, you'd be happy?
My Lord, indeed we acknowledge that taxation is the prerogative of the state, and they have to tax the citizens in order to collect revenue. But in doing this, as provided by the Constitution, they have to ensure that the burden of taxation is shared fairly. And from this, they only taxed the employee salaries from the formal income and left the informal income excluded without any justification. And therefore, we submit that this was discriminative and the burden of taxation was not shared fairly. My Lord, I do note your concern, but we submit that this court has the power to interpret the Constitution, and Article 201 of the Constitution provides that the burden of taxation shall be shared fairly. Therefore, base our submissions on these, honourable justices. Allow me to move to our fourth issue, where the petitioner submits that the police used disproportionate force to disperse the demonstrators in Wahala. Your Excellencies, the Constitution guarantees every citizen the right to human dignity and the right to freedom and security of the person. It imposes a duty on all state organs, including the police, to uphold these rights, where the police should uphold these rights by ensuring security during demonstrations. We concede that the right to assemble and picket under Article 37 of the Constitution is subject to limitations for maintenance of national security. However, the police are required to employ reasonable force and use the proportionality test as provided by the National Police Service Act in dispersing demonstrators. My lords, in paragraph 29 of the fact sheet, the police were armed with truncheons, water cannons, tear gas, and fired bullets against the citizens who were only armed with stones. The police proceeded to mercilessly launch these weapons. My lady, I clearly don't have the legal difference to that, but we submit that the protesters are supposed to be unarmed and the protests are supposed to be peaceful. We acknowledge that fact. And seeing that my time is far much used, I'd like to ask the court for a discretionary 1 minute to conclude on my submissions.
You'll have your 1 minute.
Thank you for your grace. My lord, the police proceeded to mercilessly launch these weapons at the demonstrators. This resulted to people dying and some being seriously injured by the police during the demonstrations. My lady, as seen under paragraph 30 of the facts, we see that 30 people were seriously injured and 2 people killed during the demonstrations. My lord, this was a report given by the Human Rights Watch. Therefore, rely on the doctrine of circumstantial evidence to show that it was indeed the police who caused the death and the injuries during the demonstrations. The petitioner thus contends that the use of force was excessive and disproportionate as it was beyond what was required in these particular circumstances to attain the required objective. Thank you, my lord. I respectfully yield the floor to my co-counsel, who will demonstrate how the state's violation of the principles of public finance has led to its failure to progressively realize socio-economic rights and later on address the state's failure to adhere to the data protection regulations. Thank you, Honorable Justices.
Presiding Judge, I'm ready when you are. Presiding Judge, thank you. Presiding Judge, Honorable Justices, greetings and may it please this court. My name is Cynthia Liego Jebet, second counsel appearing on behalf of the applicant. I'll be guiding this honorable court on issue 2 and issue 3, pertaining to whether the government met its obligation in relation to social economic rights and on whether the government adhered to the data protection regulations and the Constitution in the implementation of the digital ID. With the permission of the court, I would love to proceed to my submissions. Turning to the second issue, it is our submission that the state violated its obligation in relation to the social economic rights guaranteed under Article 43 of the Constitution of Kimetulik, and we shall substantiate this in 2 limbs. First, that the state violated its obligation to respect the right to education, and second, that the state violated its obligation to respect the right to food. Members of the bench, we submit that all rights are interrelated and interdependent. Therefore, the violation of these 2 rights sets off a domino effect, culminating in the violation of other rights guaranteed to the citizens. With that, I will turn to the first limb on the right to education. Members of the bench, this right is guaranteed under Article 43 of the Constitution of Kimetulik. Further, Article 55 of the Constitution of Kimetulik provides that the state should take measures to ensure that the youth have access to relevant education and training. The Supreme Court also in Moot Welfare Society versus the Attorney General, Moot Welfare Society versus the Kenya Airports Authority at paragraph 27, the court stated that the state should take legislative, policy, and other measures to progressively realize social economic rights. This also includes the right to education. However, contrary to the provisions of the Constitution and even the Supreme Court ruling, the respondent took a retrogressive measure. Members of the bench? Yes. Yes.
Timeline to it.
We do acknowledge that indeed there is no specific timeline for the progressive realization of social economic rights. However, in this case that I've stated, the Moot Welfare Society versus the Kenya Airports Authority, the court established that the fact that there is no specific timeline for the progressive realization of social economic rights does not mean that a petitioner cannot approach the court to enforce their social economic rights.
Counsel, I don't think my brother's point was towards your presence. It's about what then are they doing wrong. If there is no timeline and yet we can see from the fact sheet specific efforts towards putting money to realization of some of these rights, what are they doing wrong that's aggrieving you this badly?
Allow me to answer your question, presiding judge, in my subsequent submissions. On the first, I stated that the state took a retrogressive measure. And at this point, several points need to be made clear. That first, what is a retrogressive measure? A retrogressive measure is one that results in the backward movement in the enjoyment of a right. And second, that the Committee on Economic and Social and Economic Rights, in the interpretation of the prohibition of a retrogressive measure, in general comment number 3 at paragraph 9, stated that a state should only adopt a retrogressive measure as a means of last resort. It further established a criteria to justify any retrogressive measure taken by the state. And this include...
I'm interested in the answer to that question. Are you able to answer it now, rather than later?
Yes, I would love to answer that. There are indeed standards for progressive realization. This includes the obligation to take steps, the prohibition of retrogressive measures, and it is the maximum utilization of the available resources. And it is our assertion that instead of taking a progressive measure, the respondent took a retrogressive measure. And on the maximum utilization of resources, I shall demonstrate that in my second limb. We also wish to rely on the case of John Kabui Mwai versus the Kenya National Examination Council, where the court stated that the inclusion of social economic rights is aimed at achieving the social needs inclusive of those who are poor. It is therefore our submission that, as seen under paragraph 16 of the fact sheet, the state deliberately introduced a retrogressive measure without any justification and consultation with the affected groups. The state introduced policies that saw the revision of fee structures of higher learning institutions, and this significantly increased the annual fee payable from a mere 30,000 Kenya shillings to a whopping 100,000 Kenya shillings. And what was the resultant effect of this? Members of the bench, the resultant effect is also seen under the same paragraph, that 75% of students could not be able to enroll for the same. Additionally, many other students were not able to attend these higher learning institutions due to the policies that had been introduced by the government.
Council, let me just take you back
Yes.
before we go further.
Yes.
I'd like to understand whether Kimetolik is a monist or a dualist state. And then I'd like to get the legal framework for these social and economic rights as a foundation of your argument.
Allow me to answer your question. First, that Kimetolik is a hybrid state. It is between being a monist and a dualist. And to answer your question on why we are relying on the Committee on Economic and Social, the general comment, I would love to refer you to the case of Moot Welfare Society versus the Kenya Airports Authority, decided at the Supreme Court, where the court stated that by dint of Article 2(6) of the Constitution of Kimetolik, that indeed any convention or treaty ratified by the country shall form part of the laws of Kenya. We do submit that Kenya has not ratified this treaty, but the court interpreted that by dint of them, this being an optional protocol, they are therefore bound to the provisions of the same. Moving on to my submissions relating to the right to education, I had clearly stated that the resultant effect of the revision of these policies was that 75% of students could not be able to enroll. And to put this into perspective, members of the bench, in a country where the majority of the populations are the youth, out of every 100 young persons, only 25 can be able to attend for the same, considering that other prevailing circumstances, such as hunger, has not yet caught up with them. We therefore submit that the first and second respondent took a retrogressive measure, failed to include the marginalized in their policies, violating their obligation to respect, and ultimately denying their citizens the right to education.
Council, sorry. Is the right to education open-ended, or it's the right to basic education?
I will really love to answer your question relating on the right to education. We submit that indeed primary education should be primary and basic education should be compulsory and free. However, in relation to higher education, the state has the obligation to ensure that it's generally available and there is progressive introduction of the same. But according to the fact, we are seeing that the state is taking a retrogressive measure in relation to the same rights to higher education.
And Council, if the measure is applied uniformly to everyone, it cannot be discriminatory, can it?
Indeed, if it is applied the same to everyone, it cannot be discriminatory. But in the case of John Kabui Mwai, it was stated that the inclusion of these social economic rights is aimed at achieving the social needs, especially of those who are poor, to achieve equity. And as we've seen by the introduction of these policies, those who are highly affected by this are the vulnerable and the marginalized who are not able to access the same.
Has the state provided access to optional financing to the indigent?
Indeed, we acknowledge that the state has given bursaries and student loans to the students after changing the policies. However, in progressive realization, one of the legal standards is an obligation to take steps and being seen to take steps. And regardless of the fact that the state has introduced this HELB and other bursaries, we are still seeing that 75% of the students could not be able to attend for the same.
And in that case, then, is the problem really the introduction of new taxes? And are you saying that any increase in the amount of money that you're paying in fee is retrogressive by the state regardless of any other consequence to it? They cannot increase fees. Is that what you're trying to say?
We acknowledge that indeed the state can increase fees. However, our bone of contention was the fact that there was not sufficient consultation with the affected groups who are going to be highly affected by these policies. Turning to the second limb on the violation.
So the argument is the non-participation, not retrogressiveness.
It is a retrogressive measure introduced. We acknowledge that retrogressive measures are not prohibited. However, in the introduction of these retrogressive measures, there are some criteria that there is a criteria that was established that the state should follow in the same. And the state has not followed this criteria in rolling out the retrogressive measure.
Council, if you're saying retrogressive measures are not prohibited, then what about minimum core obligations?
In adoption of a retrogressive measure, my lord, that does not take the minimum core obligation of the state towards the realization of these rights. Turning to the second limb, on the violation of the right to food, we indeed acknowledge that this right is subject to progressive realization, which may be affected by the availability of resources. However, we wish to rely on the case of Matthew Okwanda versus the Minister of Health, where the court stated that in applying any right under Article 43 of the Constitution, that if the state claims it does not have adequate resources to implement the right, the court shall be guided by the principle that in allocating resources, the state should have ensured the widest possible enjoyment of this right. And it is our submission that the state did not adhere to this principle.
Would you then concede that the taxation measures are necessary for the state to achieve these rights, to realize these rights?
Kindly rephrase your question, my lord.
That the taxation measures,
yes,
the increase of taxes, is necessary because the state needs to have resources to realize the rights, including the right to education.
Yes.
So the means justifies the end.
Okay. We indeed acknowledge that the government needs to collect taxes to generate revenue to ensure that it has met its obligation in relation to social economic rights. However, our bone of contention, as the first council had already stated, was in the 3% housing levy. We are not objected to the government imposing taxes, but our bone of contention was on that levy that resulted, that we claimed was actually discriminatory. I would love to proceed to my submission, seeing that my time is running very fast.
Would you please address us on your second head of argument? You have 4 minutes.
Second limb of argument on the right to food.
No.
Oh, thank you. Having submitted on the second issue, I shall proceed to deliberate on the third issue, and we submit that the respondent violated the Constitution and the data protection regulations in the implementation of the digital ID. We acknowledge that this digital ID was rolled out to ensure effective tax collection and effective delivery of services. However, our bone of contention is actually in how the process was rolled out. And to that end, we shall argue in two limbs. First, that the state failed to put in place measures to protect the right to privacy. And second, that the state failed to adhere to the principle of data minimization.
Why didn't you take this complaint to the Data Protection Commissioner? Under
we
the
indeed.
Data Protection Act.
Oh, sorry.
Under the Data Protection Act, Data Protection Commissioner, why is hearing this matter?
We indeed acknowledge that Section 9 of the Data Protection Act vests the Data Commissioner with the responsibility of determining whether a citizen's right and relating to Article 31 has been violated. However, as my co-counsel had earlier stated, that these matters are interrelated and interconnected, and therefore they need to be addressed holistically by this honorable bench. On the right to privacy, this right is guaranteed under Article 31 of the Constitution of Kimetulik, and it guarantees a person's right not to have their information required unnecessarily. And in relation to data protection, it can be understood as a level of control over one's personal information. This right imposes both a positive and a negative content on the state. And on the positive content, it imposes an obligation on the state to take all necessary measures to ensure that the privacy of an individual is protected. And Section 41 of the Data Protection Act encompasses this. And it provides that every data processor, including the government, should implement appropriate technical and organizational measures designed to implement the protection of the right to privacy. We humbly submit that the state failed to meet this positive content. And as seen under paragraph 25 of the fact sheet, members of the bench, a report by the Data Impact Assessment indicated that the state had not conducted sufficient consultation in relation to the protection of the right to privacy. And second, that a cyber attack on the e-citizens platform indicates that the state has not put in place any sufficient infrastructure in its system to safeguard any information that it collects. And we therefore submit that this threatened to infringe the citizens' right to privacy if such information landed in the hands of third parties.
So your claim today is to prevent a threatened infringement, not an actual infringement?
Yes, we indeed, yes. Turning to the second limb on the data minimization principle, this is encompassed under Section 25 of the Data Protection Act, requiring that a data processor should only collect data that is adequate, relevant, and limited to the specific purpose. Members of the bench, seeing that I have 30 seconds.
I'm a little bit confused because on one hand, you're talking about the security of the system,
yes,
which means it's a different limb from whether the data collected should actually be collected by the government. What is your argument? That the government should not have collected and asked for this data? Or are you saying that they should provide more security but collect the data?
Seeing that I have only 30 seconds left, I ask for a discretionary 1 minute, 30 seconds to sum up everything related to the question.
Please go on.
Okay. Now, our argument is that first, the state failed to put sufficient safeguards. That even if it is lawful for them to collect this data, they don't have any safeguards to protect the same data. And on our second limb, we're saying that actually this data that the government is collected is beyond what is required for the specific purpose. And I hope, my lady, you are with me to this point. Okay. We submit that the collection of GPS and biometric data was unnecessary and intrusive. And this was established in the case of the Nubian Rights Forum versus the Attorney General, where the court stated that the collection of GPS and biometric data and other personal information for the purposes of identification was unnecessary and intrusive. Members of the bench, it is our submission that the state unlawfully rolled out...
Would you concede that in Human Rights Forum there was no law, but now there's a law, so that there's really a difference between those two cases?
The
Data Protection Act was not there
yes.
when we decided Human Rights Forum, but now we have the Data Protection Act. So there's a difference between those two cases. They're distinguishable. Would you concede that point?
Yes, I indeed concede that the situations are similar, considering that in the Nubian Rights Forum, the Data Protection Act was not yet enacted, but in this case, the Data Protection Act is enacted. And if we are to take that approach, we still retain our arguments that the state has not put in place sufficient safeguards to protect the data that it has collected. Having submitted on my issues, members of the bench, the decision before you is not to create a new set of rights or impose a new set of obligations on the state, but rather to affirm the existing rights and to vindicate the citizens from the suffering that they have been sanctioned by the state. And with that, we retain our prayers as they are in our submissions, and we respectfully yield the floor back to the court.
Thank you, Council. The respondents, that you're ready.
May it please this honorable court, my name is Oware Felicity Dea, the first respondent, the first counsel standing on behalf of the respondents.
Just 1 second, please. I'll ask you to reintroduce yourself, please.
May it please this honorable court, my name is Oware Felicity Dea, the first counsel appearing on behalf of the respondents. My co-counsel beside me is Naomi Kathamba. We plan to use the time allocated to us by this honorable court as follows. I will be using 19 minutes to deliberate on the preliminary issues, as well as issues A on public finance and C on data protection. My co-counsel will be using the remaining 16 minutes to deliberate on issues B, on social economic rights, and D, on the alleged use of excessive force by the police. With the permission of the court, I move to preliminary issues. The respondents concur with the petitioners in averring the jurisdiction of this court pursuant to Article 165 of the Able Constitution of Kimetulik. In matters admissibility, in the face of averring the jurisdiction of this court, the respondents contest the admissibility of issue C, tabled before this court for failure to comply with the doctrine of exhaustion. Article 159 of the Constitution of Kimetulik mandates the judiciary to uphold alternative dispute resolution mechanisms. And in the case of Geoffrey Muthiga Kabiru versus Samuel Munga Henry, a case that was heard before the Court of Appeal, whose decision is binding before this honorable court, it was held that where an alternative dispute resolution mechanism exists, the same be exhausted before the jurisdiction of the court is invoked.
Are there exceptions to that doctrine?
Indeed, my lord. We are aware of the fact that Section 51 of the Data Protection Act, in this matter, issue C, clearly stipulates that in issues or matters of public interest, there are instances where alternative dispute resolution mechanisms can be put aside. However, it is our submission that putting away this issue, that not seeking the intervention of the Data Commissioner pursuant to Section 56 of the Data Protection Act would amount to an unfair trial on the side of the respondents. This is because one of the functions of the Data Commissioner pursuant to Section 8 of the Data Protection Act is actually to investigate issues or complaints that have been lodged before him. Tabling this issue before investigation amounts to unfair trial on the side of the respondents.
Council, what I mean is, for a remedy to be alternative, an alternative remedy must be effective, must be available. You cannot force the petitioners to exhaust a remedy which is not adequate, not available, inaccessible to them, ineffective. So, in this case, isn't this a case which this court should hear instead of sending them away where they will not get any other relief?
Much obliged, my lord. We are not contesting that this issue can be heard before the High Court, seeing that some of the remedies that the petitioners are seeking cannot be able to be provided sufficiently by the Office of the Data Commissioner. We are simply saying that what should have been followed first was to first go to the Office of the Data Commissioner for there to be investigations. From that point, then they can be able to table this issue and seek the relevant remedies.
Do you concede, though, that we can hear this case?
Yes. However, should this honorable court find that the issue tabled before this court is admissible, the respondents are ready and willing to respond. Moving swiftly into the substantive issues. As a government that comes face to face with the debt crisis that has crippled the country's economy for over a decade, our core desire is to see that future generations do not suffer the same fate. Issue A tabled before this court is on the alleged imposition of excessive tax obligations on the citizens of Kimetulik by the government and failure to follow due process in the enactment of the Finance Act of 2023. We seek to respond to the submissions of the petitioners in two limbs of argument. First, the petitioners faulted the government for failure to carry out an effective public participation. However, members of the bench, move with me to paragraph 18 of the fact sheet. Here, we can clearly see that the government embarked and fashioned a program for public participation by releasing an email for submission of suggestions and opinions of the citizens on the proposed finance bill. This is actually in compliance with the stated case that they had stated, the case of Muikol Basin case, where it was held that it is upon the government to fashion a program for public participation.
Why email, Council? Emails are individual. It's not a group, unless you're telling me your state has a group email that goes to everyone in the country. And the fact sheet tells me that most of your citizenry use X. Why email when it is known or ought to have been known that there's a greater outreach through a different media?
Much obliged to answer your question, my lord. In this, I would like to cite the particular case of Minister of Health versus Nuclex, where it was clearly stated that what amounts to a reasonable opportunity or reasonable time is clearly at the discretion of the court, and it ought to be discussed on a case-to-case basis. On the issue of email being a reasonable opportunity, putting into consideration that there is X, which is a social media platform, we seek to strongly be guided by paragraph 4 of the fact sheet, where we can clearly see that 90% of Kimetulikans actually participate on polls or any debates concerning government matters through social media platforms, and emphasis has been placed on X, true. But email is still a social media platform, and we submit that it is reasonable.
90% participate on polls.
Yes.
Actively participate through online discussions.
Yes.
Is there any suggestion that that is, or those participations have been by email in any instance, or that even email, the only thing we're told is X has a greater outreach than email or than any other? Why email? That's the question. And as you've correctly told us, it's a case-by-case basis. Now, looking at the fact sheet, that's why we are asking you, why email, not X, if you are going to go by way of social media?
My lord, I take note of your concern, and it is our submission that email was in fact reasonable, because pursuant to the fact sheet, we can clearly see that there were responses that were actually gathered through this means of public participation, and therefore it would be reasonable.
Council 140 of those responses
Yes.
were opposed to this bill in its entirety. Why did you go ahead with it? You asked for email views are sent. 140 participants are opposed to the bill entirely. But you still enact it the way it was. Why?
I want to first ensure that I have gotten your question correctly. My Lord, are you asking on why we did not why the views of the 140 stakeholders do not reflect the decisions of the government?
Yes.
In this, my Lord, allow me to cite the case of Associations of Gaming Operations Kenya versus the Attorney General. In this case, it was held that public participation cannot be negated simply because the decisions of the government do not reflect those that are gathered through suggestions and opinions of the citizens.
The issue is how widespread, what is the population of the country?
My Lord, the fact sheet has remained silent on the actual population of the citizens.
Yes, so it's not clear, but at some point we know that the population is somewhere beyond 14 point something million within the fact sheet.
My Lord, I am not aware of that, and I seek to be guided by you.
So is it you argument that 140 actually is a proper and reasonable representation of the entire population?
My Lord, in the case of Robert N. Gakuru case versus the governor of Kiambu County, it was held that public participation does not mean that everybody ought to give their view. And the 140 stakeholders is a simple sample that can indeed stand for the whole population. The second limb of argument is on the alleged imposition of excessive tax obligations on the citizens by the government. It is our submission as the respondents that the taxes imposed were in fact not discriminatory or excessive, but they were selective in nature. Allow me to cite the case of Okello versus the National Assembly, where this honorable court stated and clearly held that taxes need not be the same, and selective taxes can be applied so long as it is rational with a genuine public interest. Paragraph 12 of the fact sheet, members of the bench, when you move with me, highlights the debt crisis at hand. As of 2022, we are standing face to face.
Council, when you impose the same measure on everyone, yet everyone is not the same, don't we have indirect discrimination? And where there's that, don't you have an obligation to undertake affirmative action?
My Lord, in the implementation of the proposed finance bill, we are not taxing everyone the same. We have clearly created a severance between informal businesses and those who are formally employed, so as to not create a taxation system that would amount to double taxation. Our system of taxation is not taxing everybody equally, and that is as of the case that I have simply stated. So taxes need not be the same, and selective taxes can be applied so long as it is rational with a genuine public interest.
Would you then concede that they are right in saying that the taxes are discriminatory if they are not the same?
No, my Lord, we do not concur with them, simply because if we had applied the 3% housing levy on those business owners who we have already imposed a 1% mandatory business turnover, it would amount to a system of double taxation. And in the case of George Selelo, it was held that, allow me to read that case quite well so that I do not mislead this court. In the case of George Selelo, it was clearly held that a taxation system which would allow for a double taxation would be unequitable. The article that they have cited, Article 209, indeed provides that the burden of taxation be shared to be shared. Pardon?
201.
Yes, Article 201 clearly states that the burden of taxation be shared fairly. It does not mean that everybody be taxed the same.
Allow me to take you back to something that you said that intrigues me. You said that your taxation was selective, not discriminatory. Would you please demarcate those clear boundaries between the two for me?
A tax that is discriminatory would be one that is targeting a specific class or a specific gender or any other specification that has been given to amount to discrimination under the Constitution. But a selective tax is one that draws a system of rationality with a genuine public interest.
So discriminatory would be one that says employed persons should pay, or would that be selective? What is the rationality or the logical rationale that you're drawing? Because for me, by your definition, when I say the employed, then I have discriminated as with regard to those in formal employment.
My Lord, the provision of being employed or unemployed is not stipulated as one of the circumstances where we could draw discrimination from in accordance with the Constitution. It is clearly on class, on age, on gender. It does not speak on employment status.
And the demarcations of the Constitution are exhaustive in that regard?
No, it is at the discretion of the court. Having done justice to the first issue, I seek to proceed to issue C, tabled before this court. This is the issue on the alleged failure of the government to comply with data protection regulation and the Constitution in implementation of the digital ID. We seek to respond to the submissions of the petitioners in two limbs of argument. First, that we actually adhered to the right to privacy, and limitation, if any, was justifiable and reasonable as provided for under Article 27 of the Constitution of Kimetulik, that demands it be reasonable and justifiable. This is because the limitation that was expressed by the government satisfies the analysis test that was set out in the case of Okia Omtata versus Communications Authority of Kenya. In this case, the government sought to implement a surveillance system dubbed the device management system, and the court developed a two-part test. First, that there be establishment of a valid rational connection between the limitation and a genuine public interest. As I have led you members of the bench to paragraph 12 of the fact sheet, we can see that as of 2022, the government is standing and looking face to face with an 8.66 trillion debt burden. The limitation of the right to privacy is the limitation in this case, and the valid rational connection, and the genuine public interest in this case is the need to effectively curb tax evasion.
Again, the argument by the applicants or the petitioners before us is that the doctrine of minimalization of data comes into play. You're getting GPS coordinates and all. What does that have to do with your valid rational connection and your bio data equally?
Indeed, I take note of your concern on the principle of data minimalism, and it is our submission as the respondents that the government actually upheld this. The petitioners have tried to rely on the Nubian rights case, and we would seek to rely on the Musheru versus Katiba Institute case, a case that was held before the Court of Appeal, whose decision is also binding before this court. In this case, the government sought to implement an identification number which they had dubbed the Huduma number, and we are aware of the holding of this court. The court held that collection of data, sensitive data, such as GPS coordinates and DNA is intrusive, unnecessary, and unconstitutional as it violates Article 31. However, we seek to draw a contrast with this case in our case. In that case, the government did not carry out a data protection impact assessment. However, in our case, when you move with me to paragraph 25 of the fact sheet, my lords, you will see that the data commissioner took a proactive step in carrying out a data protection impact assessment. And thus, we can clearly draw the conclusion that the government took necessary steps to be able to secure such sensitive personal data. Also,
in paragraph 24, you force people to register out of fear. And would you concede that the data protection impact assessment by the Data Protection Commissioner is illegal because it's not the Data Protection Commissioner to conduct the DPI. The DPI should be done by you, the person seeking to control or process the data?
To answer your two questions, first, the assessment by the Data Commissioner is in fact one of the powers that the Data Commissioner has under Section under Section 9 of the Data Protection Act. And on the allegations that the words of the CS amount to coercion and that the citizens were forced to register, we take note that the citizens actually registered out of fear. However, it was not the government's intent to coerce the citizens. They were simply according them their right to access to information, because the government would not want a situation whereby the citizens are being barred from government services. Imagine a scenario where we did not...
Why do you impose that condition on them, that if you don't register for this new thing, you have no access to government services?
Certainly, my lord. I would like to draw the scenario of how things would have looked without that statement. If the government starts the registration process without telling the citizens that they would be barred from accessing government services, we would have a situation whereby they are being barred, and yet they are being barred because they did not have the right to access to information. Had they known, they would have registered. We were simply according them the right to access to information so that we would not have a scenario where citizens have not registered and are being barred from accessing government services.
Council, still on that issue of fear, considering the circumstances that everybody registered because they were fearful, they did not understand, how does that impact the legitimacy of your approach? Specifically because there needs to be public participation, they need to be informed as to why they are doing it, but they were still afraid. Would it be right for us to conclude that this public participation was not sufficient, your information was not sufficient?
On the sufficiency of, to answer your question, my lord, I would like to seek a discretionary 1 minute and 30 seconds.
You have it, please proceed.
Section 25 of the Data Protection Act clearly states that data only be collected and processed where a valid explanation has been given. My lady, move with me to paragraph 26 of the fact sheet. We can clearly see that the Cabinet Secretary informed the citizens that there was need for the implementation of the digital ID in order to curb tax evasion and also for identification. The President also emphasizes this under paragraph 27 of the fact sheet, where he states that it is for to create a whole uniform unit within the citizens, to unify the citizens. On sufficiency of what amounts to access to information, my lord, my lady, seeing that I am not privy to that, I would like to stand guided.
Council, as much as your time is up, I'd like to take you to one final clarification. You have just answered to my brother's question that it is the duty of the Data Commissioner to do a DPIA under Section 9 of the Data Protection Act. Are you able to tell us under Section 9 what subsection? Because I do not seem to see that in Section 9.
There is no obligation of the Data Commissioner to carry out a data protection impact assessment. However,
is it his power?
Pardon?
The question was, is it his power, his authority, his mandate to do a DPIA?
No.
Or is it on the state?
No, allow me to retract that statement and reinforce the argument by saying it is one of the functions that can be carried out by the Data Commissioner.
So it is not a delegated
No,
authority.
it is not a power that is specifically given to the Data Commissioner. To conclude on that argument, drawing contrast to the Musheru versus Katiba Institute, the reason the collection of GPS coordinates and DNA was held to be unintrusive, unconstitutional, and absolutely unnecessary was because it was simply for identification purposes. However, in our case, it is not simply for identification purposes, but as stated, it is also for uniformity and to be able to curb tax evasion.
Thank you, Council.
Thank you.
Having sufficiently concluded, I cede the floor to the second council to deliberate on the remaining issues. Thank you.
Greetings, honorable members of the bench. As introduced by my lead counsel, I am Kanamba Naomi, appearing as the second counsel for the respondent. I will be taking 16 minutes of this Honorable Court's time to guide you members of the bench through the second issue, the question on socioeconomic rights, and the fourth issue on the alleged use of excessive force by police. Unless I'm directed otherwise, members of the bench, I want to begin. The second issue, which is the question on socioeconomic rights, will be presented before you members of the bench in two limbs of argument. My lords and my ladies, we submit before this Honorable Court that the government of Kimetulik has adhered to Article 21(2) of the Constitution, which mandates that it takes progressive steps to realize socioeconomic rights. We further submit that we have obeyed Article 25(b) of the Constitution, which says that the government should prioritize the widest enjoyment of socioeconomic rights under the prevailing circumstances and with the available resources. My lords and my ladies, Article 2(1) of the International Covenant on Economic, Social and Cultural Rights obligates governments to take continuous and sustainable steps to realize socioeconomic rights. May I persuade this court by relying on the advisory opinions given by both houses of parliament in 2012 on the principles of gender representation, where it was set out that the government is not mandated to take any particular steps at any particular time, except where the Constitution stipulates a time frame. Members of the bench.
Since then, the Supreme Court has said otherwise in William Musembi, in Moi Educational Center.
My Lord, may I guide you members of the bench to paragraph 14 of the compromise, as I try to demonstrate that the government of Kimetulik has not taken a backseat in the realization of socioeconomic rights. In paragraph...
Before you go to the fact sheet, do you acknowledge that the position in law that you stated has since changed?
Yes, my Lord, we do retract our statements. May I guide you members of the bench to paragraph 14 of the compromise. It is clearly stated that the government of Kimetulik tries to bring into force the National Housing Development Fund in its effort to make sure that it upholds the socioeconomic right of access to affordable housing of reasonable standards. Further, members of the bench, follow me to paragraphs 16 and 17 of the compromise, where it is demonstrated the steps that the government of Kimetulik takes in terms of upholding Article 55 of the Constitution of Kimetulik on access to education. Because in these two paragraphs, members of the bench, it is well stated that the government of Kimetulik increases bursaries and increases loans. We do concede that when the government revises the fee structures from 30,000 to 70,000, it causes dismay and disruption among the citizens. And in response, members of the bench, the government issues circulars enabling the youth of Kimetulik to access free courses in technical colleges.
So it's okay if you can't go to university, go to a polytechnic.
My Lord, we submit...
That's the message that the government is sending. If you can't afford our universities, go to a TVET, mandatorily.
My Lord, we submit on this issue that the government of Kimetulik is guided by the South African case of Subramani versus Minister of Health in terms of education, as carried out its obligation, its minimum co-obligation, because it has satisfied the right of education to the minimum essential level. We present before this court that the Basic Education Act does mandate the government to provide free education, not tertiary education, my Lord. Members of the bench, if I may move to my second limb of argument, that the government of Kimetulik is facing financial constraints. May I guide you to paragraph 1 of the compromise, members of the bench. The government of Kimetulik is a developing country with a GDP of just about 95.5 billion. Again, the Constitutional Court of South Africa in 1997, on the case of Subramani versus Minister of Health, called for a holistic approach when the courts deal with issues socioeconomic rights, because these issues require plenty of resources. Members of the bench, move with me to paragraph 5 of the compromise. The government of Kimetulik is collecting revenue, but its revenue is at 25% low than the target that has been set by the East Mau community. The petitioners have submitted in vast on the fact that the government is setting aside a lot of funds to service the debt. May I then guide you to paragraph 12 of the compromise, members of the bench. The debt of Kimetulik stands at 8.66 trillion. And in paragraph 11, we can see that some debts like the Eurobond are set to mature by the end of the year. Members of the bench, the government of Kimetulik must then set aside funds to clear these debts.
When you are setting aside funds to clear the debt, aren't you also obligated by Article 21 to use the most available resources to the best of your availability, availability of the resources to fulfill these rights. That's one. And then two, what about the claim that increasing fees was a retrogressive measure? Though you spoke about retrogressive measures. You earlier told us about progressiveness, but then are you allowed to take a retrogressive measure?
Much obliged, my lord. To answer your two questions, I will first admit before this honorable bench that budgets are not cast on stone. My lords and my ladies, the government reviews budgets annually. And because the budgets are thus flexible, it enables the budget to accommodate the circumstances that have emerged during the course of the year. The government of Kimetulik notes the concern of the bench when it comes to the food security situation in Kimetulik in terms of the retrogressive step. And we want to assure the bench that we do have the plight of the citizens at heart. My lord, we also want to submit before this honorable court that when the government sets aside funds for other sectors, it might also indirectly promote socioeconomic rights. Moving members of the bench to paragraph 10 of the compromise. It is stated that the government set aside 183 billion for energy and infrastructure and 718 billion for development. We want to submit before this court that when the government makes it able for, or rather when the government improves infrastructure, transport infrastructure, communication infrastructure, it is also able to reach out even to the most remote areas of the country and provide health, provide education, provide housing facilities. Finally, members of the bench, Article 20, Clause 5C of the Constitution of Kimetulik underscores the facts that no court, no tribunal, and no authority is to interfere with the mandate of the government to allocate the budget, simply because it feels it would reach a different conclusion. With your permission, members of the bench, allow me to move into the fourth issue.
Of course, the government has discretion, but one of the most fundamental socio-economic rights is the right to food. Paragraph 2, the country is majorly agricultural. But you look at, when you go to paragraph 10, the allocation to agriculture keeps reducing with every budget, with every board. Don't you think that that generally affects the right to food and perhaps every other right?
In fact, isn't that a further retrogressive measure comparable to the school fee that you've also increased?
Members of the bench, we note the concern of the bench in terms of the prevailing food insecurity situation in Kimetulik. We like to submit before this honorable bench that it might be a little bit difficult, my lord, for the government to provide food to every household on a one-on-one basis. What the government can do to make sure that the citizens of Kimetulik can buy their own food, members of the bench, is to create employment opportunities. And for that, may I draw your attention to paragraphs 8, 14, and 17 of the fact sheet. It is well stated the measures that the government has taken in trying to enable the citizens of Kimetulik to get jobs.
Isn't it also true that at paragraph 2, the agricultural sector accounts for 80% of national employment? That means that the government needed to put as much resources in that sector as possible so as to create employment.
My lord, the benefits of the agricultural sector to the economy of Kimetulik are not disputed.
But if it is not disputed, the point that we are making, you have a sector that is employing the most and providing the most, both to your GDP and even in employment and food security. By giving it less and less in your budgetary allocations, which you say we should not look into or we cannot dictate, aren't you taking a retrogressive measure? You're telling us, I'm burning down your house, but at least I'm making the loan, and I should be happy about that.
My lord,
we are not asking you to give food to everyone individually. You're reducing their capacity to do that.
My lord, we do concede that when the government of Kimetulik reduced the budget by 10 billion, it caused various negative results to the sector of agriculture, including the removal of subsidies on fertilizers. And my lord, for that, I will echo what I said earlier, that the government of Kimetulik has taken notice of the adverse effects of the reduction of the budget to the sector of agriculture, and that since these budgets are flexible, we do have the plight of the citizens at heart.
In the meantime, we should allow this petition as prayed, shouldn't we?
Pardon me?
We should then allow the petition as prayed if the government acknowledges the impact of its actions.
My Lord, I also quoted that the benefits of other sectors like energy, infrastructure, and development are very important to the sector of agriculture. The government has not only, when the government reduced the budgets, members of the bench, it increased the budgets to the sector of infrastructure. And as I had demonstrated earlier, infrastructural development have a big bearing on socioeconomic rights. The petitioners are presented before this honorable court that the government of Kimetulik has disregarded, not protected, not fulfilled socioeconomic rights.
Council, you earlier on spoke about the ability of people to put food on the table. And when in the midst of an economic crisis, you double VAT from 8 to 16% on food products, on fuel, and we know that people have different incomes. Don't you disproportionately burden the low-income families because they spend more on their food, right? Isn't that a regressive tax which we should nullify under Article 201? Doubling VAT on fuel and food in an economic crisis.
My Lord, to that we respond that, as I demonstrated earlier, the government of Kimetulik has tried to create job opportunities to enable the citizens of Kimetulik to have a higher purchasing power, even in the face of the increase in VAT. And my Lord, if, with your permission, I may move to the fourth issue, seeing that my time is far much spent. Thank you, members of the bench. This issue will also be presented before this honorable court in two limbs of argument. My lords and my ladies, as seen in paragraph 1 of the compromise, the government of Kimetulik is one that takes pride in its protection of rights and freedoms and in its protection of a democratic governance system. Members of the bench, Article 37 of the Constitution of Kimetulik enshrines the right of every citizen to demonstrate, to assemble, to picket, and to present petitions before government authorities. It therefore gives the citizens an alternative way, other than just elections, for them to participate in government. However, Article 25 of the Constitution does not set out this right as being absolute. And as a matter of fact, in Article 24(5)(c), it is well stated that the Kenya Defence Forces and the National Police Service can limit Article 37. Members of the bench, further Section 5(8) of the Public Order Act, particularly 5(8)(b) of the Public Order Act, vests the National Police Service with the authority to permit or to prohibit a public procession. But they do not do this arbitrarily, members of the bench.
Is it to permit? Is it to permit? Could you clarify that?
My lady, Section 5(8)(b) of the Public Order Act vests the National Police Service with the ability to regulate socioeconomic, or rather to regulate the right to assemble.
Regulate, not permit.
Yes, not to permit. But further, the same paragraph of 5(8)(b) says that a regulating officer, members of the bench, can turn down a notice to protest where there is a clear, present, or imminent danger of a breach of peace or public order. We want to submit before this court that the National Police Service do not have the power to arbitrarily limit these rights. They can't just do it anyhow. They must be guided by the Constitution. May I move with you, members of the bench, to paragraph 29 of the compromise? The reason the National Police Service give for turning down the notice to protest is that the protests do pose a security threat within Wahala. Rejecting the notice to protest, therefore, members of the bench, was not in any way
peaceful and armed protests cause fear of insecurity.
My Lord, to respond to that question, I seek to rely on the compromise because in paragraphs 29 and 30, it is clear that the protesters do breach the peace of even other non-protesters.
Council, what is the threshold?
At the time the notice is given, how does the police determine there will be a breach?
Much
Do they have a
obliged.
right to refuse the right to protest?
Much obliged, my lady. May I refer you to section 24 of the National Police Service Act?
I'd like you to look at the Constitution. This is a petition.
Yes.
Is that right limited?
Article 25 does not establish Article 37, the right to assemble, as being absolute. And as I quoted earlier, Article 24(5)(c) states that the Defence Forces and the National Police Service can limit Article 37, my lady. If I may proceed, members of the bench, Rejecting the notice was not in any way a violation of the protesters' right to protest. It was simply a preemptive measure by the National Police Service to try to mitigate the threats of peace, the loss of life, the vandalization of property, and the significant infrastructural damage that is later witnessed. Members of the bench, may I seek a discretionary minute to complete on my submissions?
You may.
Much obliged. The fact that in paragraph 29 it is well stated that the protests were turned down, that the notice to protest was turned down, means that the protest was an unlawful assembly. Section 78 of the Kimetulik Penal Code describes an unlawful assembly as a gathering of 3 or more people with the intent to commit an offense and breach peace. Members of the bench, the petitioner submitted before this court that the police breached the Constitution when they employed tear gas and water cannons. May I then submit to the contrary, guided by the United Nations 1990 Basic Principles on the Use of Force and Firearms by the Police, where it is well stated, members of the bench, that just the mere presence of the police, their uniform, their vehicles, is a peaceful measure in its own. Further to persuade you, may I rely on the 1998 case of Gulek versus Turkey, where the European Court on Human Rights established the fact that water cannons, tear gas, anti-riot gear are all peaceful measures. Members of the bench...
Counsel, is it peaceful measures? Could you...
Non-violent measures.
Non-lethal, you mean?
Yes.
Thank you.
But here 2 people died, so...
My Lord, we do feel sympathetic and apologetic towards the 30 who are injured and to the families of those who are lost. But we submit before this honorable court that these people were not targeted by the government. They were simply caught in the crossfire when the police were trying to defend themselves. And answering you will lead me to my second leap of argument.
Counsel, crossfire to mean what?
Not crossfire, quite literally.
Great. So what you're telling us, a refined conception of your argument is that the non-lethal weapons were used in a way that caused grievous harm and death.
No. What I'm trying to submit as I answer, may I take a discretionary minute, my Lord, to answer you? What I'm trying to submit as I answer you, my Lord, is that these people were not targeted. The police were trying to defend themselves, members of the bench. May I refer you to paragraph 29 of the compromise? It is well stated that while the citizens were armed with stones, they charged at police. Section 46 of the National Police Service Act entitles the police to all rights that all other citizens of Kimetulik enjoy, including the right to defend themselves. And we submit before this honorable court that the police adhered to Section 17 of the Kimetulik Penal Code because they remained within the confines of the common law when defending themselves. From the fact sheet, the threat to the police was imminent, and the force they used to defend themselves was necessary and proportionate. Further, this court in paragraph 58 of its judgment in the case of Bunjiru Wambug versus Inspector General of Police did set out the fact that for protesters to be protected by the Constitution, members of the bench, they must be unarmed and they must be peaceful. The protesters in this case had weapons. That begs the question, then what are weapons?
Thank you, Counsel.
Much obliged, my Lord. May I refer this honorable court to page 26 of our written submissions for our memorials, for our prayers. I thank the court and I cede the floor.
Rebuttal.
Judge President, Honorable Justices, it is an honor to engage with you once again. My name is Simon Kimuhu, and my mandate here is as brief as it is straightforward, to address our 2 points of rebuttal. First, on the issue of public participation, and second, on the issue of taxation. Turning to the first link on the issue of public participation, the respondents have submitted that use of emails was the most appropriate means to conduct public participation. However, we wish to rely on the same case they have relied upon, the Governor Kiambu County versus Robert Gakuru, where the court stated that where the legislation in question involves such an important aspect as payment of taxes and levies, the state should ensure that it has used as many fora as possible to ensure sufficient consultation. In the unfortunate event that this court were to agree with the respondents on this, it will be subjecting its citizens to a state of perpetual marginalization. Turning to the second limb on the issue of taxation, the respondents have stated that the taxes and revenue collection imposed by the state cannot be contested by dint of Article 25 of the Constitution of Kimetulik. However, we wish to rely on the case of Justice Society of Human Rights Alliance versus the Attorney General 2012, where the court stated that despite the doctrine of separation of powers, this court still retains authority to review decisions made by an arm of government to ensure that first, they were reasonably made, that they were compliant with the required procedures, and they were constitutional. In the unfortunate event that this court were to agree with the respondents on this, it will be stripping its citizens their basic human dignity. Members of the bench, once again, thank you for the opportunity, and with that, the petition rests.
Thank you. Bailiff will stand adjourned. This court will stand adjourned now.
You think so?
Good afternoon. How are you doing? How was the Supreme Court? It was beautiful. Did you have a wonderful moment? Are we ready to hear who has won the Moot competition and the research category for the 12th edition? Come on, let's give a round of applause for us being here and us being present for this particular occasion. Yeah, I know it has not been a smooth journey. I am a Mooter myself, and I know that it is not an easy journey preparing for a Moot, going through the preliminaries and reaching the finals. And I know the tension that is usually there when you are awaiting the results. But thank you so much for exercising patience, and we will release the results at any time from now. So I'd want to welcome you again to the All Kenyan Moot Court competition. My name is Daniel Morakaru. I am an alma mater, I'm proud to say that, of this school. 3 months old as an alma mater, and I am a legal research fellow in the Institute of Public Finance. So at this particular moment, I am going to welcome Mr. Griffiths, who is going to give us the remarks for the research category, and then we're going to hear remarks from the Moot category, and then we will go ahead with the speeches. Yes, so let's give a round of applause for Judge Griffiths. Yes.
Good afternoon. I was reminding Daniel that we have not prayed, so I think it's important that we pray. So I'll pray. Let us pray in the name of the Father, the Son, and the Holy Spirit. Amen. Dear Lord, we come unto you this afternoon. We thank you for the competition that opened earlier this week, and today the curtains draw to a close. Dear Lord, thank you for all organizers, thank you for all participants, and thank you for the event that will go down today. I pray this through Christ our Lord. Amen. In the name of the Father, the Son, and the Holy Spirit. So I stood here last year to speak about or to give remarks on behalf of my fellow research category judges. Unfortunately, I'm the only one present. I don't know why the others are yet to get here, but I'll speak about what we observed during the research. But before I begin, may I just thank all the 18, or is it 19, students who appeared before us on 13th and 14th. You all did a very good job, and the competition was very tight this time round compared to last year, especially the oral presentations. They were very, very tight. So it shows that a lot went into preparing for this edition compared to the previous edition, and whoever will win, whoever will not win, just be proud of yourself that you did an excellent job. And that's why we requested the committee, especially the head research, to give specific mentions. I believe they will give specific mentions because there are people we felt like they did exceptionally well, even though they might not feature among the top 3, but still they'll be recognized. So be as it may, there are 2 phases to this competition. We have the research paper, then we have the presentation. So we don't seem to have a lot of problems with presentation, but there is a lot of problem with the research paper. Now, compared the work that we marked last year and the work that we marked this year was a bit below standard. This year the orals were way better compared to last year, but whatever was written compared to whatever was written last year, then we had a problem this year. Let me speak about common mistakes before I go into the other issues. Common mistakes are you write a research paper, then you begin sentences with a small letter. We observed a lot of that. You begin or you don't put appropriate punctuation marks. You put a comma and then you begin a sentence. or you use a lot of Swahili words in the course of your work, and you do that repeatedly. You use very lengthy sentences. You find that a sentence is like 30 words. You use very lengthy paragraphs. A page has just 2 paragraphs or 1 paragraph, and that is a whole page. These are common mistakes that should not happen in a research paper. At least even before we look at the substance of your work, then when we look at the form, it should at least be appealing. Because if I look at your work, the form is not appealing, then I'll form a mindset that perhaps I'm not marking a paper of a very serious student. So always ensure that after you've written your research paper, you give someone else to read. You don't need to give your senior to read. You can give your peer to read, just so that these small mistakes are not observed. Spelling mistakes, starting sentences with more letters, having very long paragraphs, having very long sentences. And then now the other things that we observed, I think before you guys started writing, AKMCC conducted a training, and I remember I was requested to train those who had registered to participate in the 12th edition, and I think the session was for 2 hours on a Saturday. Now, those who followed what we said during that meeting, it was very evident, because when the papers were presented before us, you know, we have the papers as you present. Then the judges just see, and then they're like, oh, this is a very well-structured paper. Even those who did not get an opportunity to mark that paper. But unfortunately, most of you did not follow what was said during that training. Because during that training, we said how you're supposed to structure your research paper, and unfortunately, I think only 2 or 3 structured their papers that way. The rest structured their papers differently, with each person having their own different structures. So maybe just to do a quick recap, we say that the very first part is an introduction. Then in the introduction is where you have your problem statement, is where you have your research questions, is where you have your research objectives, it's where you have your theoretical framework and literature review, all under the chapter of introduction. Unfortunately, we had people structuring all these as different chapters. Then we said, in your problem statement, we should see the problem. And the easiest way for us to see the problem is that you have to paint the scenario as is first. That we have public participation. Yes, no one contests that there is public participation. And then now, what is the problem with that public participation? That is the easiest. That much as we have it, it is not meaningful. Then that is the problem. Then now, what are you suggesting in your paper? Then you have a perfect problem statement. So when I read the problem statement, then I just know what your whole paper is about. And I can grade that paper based on the problem statement alone. Then from the problem statement is now where you derive your research questions and research objectives. So the research objectives and the research questions are answered in subsequent chapters, So chapter 1 being the introduction that has already catered for all that. You have your chapter 2 answering or addressing the first research question and the first objective. Then chapter 3 addressing the second research question and the second objective, like that as you move towards the end. That is the easiest way to structure your research paper. But unfortunately, only 2 or 3 did that. Then another thing that we observed is the issue of recommendations. All of you had recommendations, but some of the recommendations are not workable, they are not achievable, or you don't explain the how. So you just give a recommendation, then you leave us to start wondering now, how is that supposed to be achieved? And we were forced during the oral presentations to actually ask you to explain how that recommendation is going to be achieved. So there is this thing called SMART: specific, measurable, achievable, then the A, then the T. So most of the recommendations that we were hearing lacked achievable and they were not measurable. So you don't just put recommendations for the sake of putting recommendations. You have to think through the recommendations, because these papers, or at least the best papers, are going to feature in the e-journal of the 12th edition. And someone is going to read this paper, and someone is going to pick some recommendations from these papers. So if you're going to have recommendations that cannot be achieved, then you'd rather even not have that paper published in the e-journal. So if you intend to participate in subsequent editions, please realize that you also have to put in work with the written script, not just the oral presentations, because before we meet you, we look at what you have written. So if it were like a Moot, where we would have to disqualify, then only those who have attained a certain mark to appear before us, then there will be a lot of trouble. Then to the AKMCC, I have a proposal, another proposal now. I don't think doing a one-off training like the one that we did is quite helpful to the participants, but perhaps you can consider and to expand the reach and the scope of AKMCC. Going forward, you can just offer training. There are people who are always willing to do these trainings on a continuous basis, so that those who have trained and wish to participate, well and good. Those who you would have trained and they do not wish to participate, well and good. And that will not only be beneficial to those who will participate in the subsequent edition, but that will also be beneficial to the AKMCC. It will carry the name of the AKMCC high. So having said that, I wish you all the best. Those who will win, congratulations. And those who will not, congratulations as well. Thank you.
Thank you. Thank you so much, Judge Griffins. I believe that all the researchers have been able to, take notes. And from what he has said, I believe that even in the next competition, we will get to see well-written papers that are deserving to be published in the All Kenyan Moot Court Competition e-journal. Yeah. So at this particular moment, I'm going to invite Mr. Alois Moi, a representative from Uraia Trust, to give his remarks. Let's give him a round of applause as he comes.
So thank you very much, and I'm happy to be here again today. So today I've just come to witness the winners and also hear about the way forward, how we're going to progress. So it's a good effort. I hope the participants did well in the presentation. The judge has highlighted some of the gaps. You didn't fail. I think they are just the gaps which we can go back and strengthen, because this is a learning session. And if we learn, we keep on improving. So congratulations for all competitors and participants who participated in the process. And it's to wish you all well as you go back. And as we said when you were opening, this is a learning session. And a learning session, we keep learning. Learning doesn't end. So what we have learned, the experiences we have shared, and all the other things, let's go back to class or to our schools and ensure that we build on them and strengthen them. So we are still happy at Uraia to associate with the All Moot Court competition, and let it not be just a one-off activity. So like the judge has said, I think there was that recommendation he has given on training. So even if you need some training, please feel free to reach to Uraia. We can support some session and ensure that when you come when you are ready. So thank you very much, and I wish the winners and also all those who participated well, and will continue with the partnership. Thank you.
Thank you so much, Mr. Alois Moe, and we are glad to continue having the partnership with Uraya Trust. Once again, let's give him a round of applause. So at this juncture, I'm going to welcome our Dean, Dr. Ratemo, to give his remarks, and he's going to invite the chief guest for this closing ceremony, and then you're going to get to the right moment of receiving the results. Are you ready? Yeah, okay. Be patient. Welcome.
I'm also waiting for that moment to receive the results. Yes, good afternoon. Good afternoon once again. I'm so happy to see you once again here. You look so, you're smiling, some stress, some tension, nervousness, but I tell you that all will be well. Don't worry. In KU, everything is well. India? Yes. So I'd like to thank each and every participant here, particularly those who have come from is it Moot University? We have from participants from Nazarene University, KC University, and Egerton University, plus Nairobi University, of course, we can't forget, MKU, JKUAT, and which one else? Strathmore, of course, Kabarak. Oh, good, Kabarak University. It's really good to have you on board. We have been here for the past, I think, 4 or 5 days. And I'm so happy that you came. Because if you had not come, of course, this AKMCC could not be the way it is right now. So I also like to thank our key sponsors. I know most of them are not here, but we have Alois here, one of them, to represent the others. It's because of them that we have managed to at least have this competition, and it's indeed a very successful competition. So in their absence, I think you can see all of them here, the main sponsors for this event, for the 12th event edition of the AKMCC. I also wish to thank our staff members, our judges. I think you noticed that during the opening ceremony we had judges from the Court of Appeal. We had the former CJ. We had also the members of the management board, etc. So it's really indeed good to have them on board as well. And also I can't forget to thank our students, KU students. You need to clap for yourselves. Yes, you have done a wonderful job. A wonderful job. It's because of you that we have had this successful event. I also wish to thank the organizing committee of the AKMCC. Let me tell you that you may see things moving on so well. From my office, if I can rate, from my office, we have done like 30% of the work. 70% of the work was done by the AKMCC organizing committee. So they really need a clap. Okay. They have really worked so well. I think that you can stand and the rest of the people see you. The organizing committee, please stand up. Yes. They really deserve a clap. You have done a very good job. I'm so proud of you guys. I know you have your own time to speak, to say something. So you can sit, please. Thank you so much for that. And for the crossing ceremony, it's unfortunate I did not participate there because I was in class teaching. But I know the best team has won, Cynthia. Yes, the best team has won. So, thank you so much. I also like to thank members of the faculties from different law schools. We have one here, my former colleague at the Catholic University of Eastern Africa. Now at the Nazarene University, you may stand and say hi. Yes, she used to be the acting dean, I think, of Nazarene University as well. So I thank you for coming. And also Griffin, thank you for coming. And who else? Our colleagues here, I can't forget. Professor Thomas, maybe you can stand, wave to the people. Yes. He's the chair of the Department of Public Law in this school. Our former dean, please wave. Yes, she's Dr. Kabata. Also, she's a member of staff at the Department of Public Law, where we all fall. So now, without wasting a lot of time, let me welcome our chief guest for today, Professor Mwimari. I think, is there anybody who does not know him? We all know him. But just to give some few things about him. He has been very vocal. He has really helped us at the School of Law here. He is the CEO of what you can see here. The National. It's in brief, we say Kenya Law. And he has been very good for the school here in terms of not only undergraduate program, but also postgraduate, which we are going to start very soon. So welcome, Professor. And this is the opportunity to say something. Thank you.
Thank you so much. Thank you so much, Dean, the organizers of this event, my colleagues. I call them my colleagues because I think all of them, I have talked with them at one place or another. The participants in this Moot, first of all, I want to congratulate you. At the beginning, we said everyone who has participated is a winner, because in any competition, unless you have people that you will go up against, then you cannot be a winner at all. For the universities that have taken time to prepare for the Moot question and come and participate, we know it takes time and effort, but as has been said, that is a good learning experience that you have. Perhaps I'll just give my own story, because one of the very first time I went into mooting was because I had participated in a debate and I didn't know what really mooting was. I think I was in my second year of studies at the university in 1999. So I had participated in a moot, in a debate, and I had done according to the judges well. In fact, in that debate, I had not prepared at all, just like I have not prepared for speech. So I went there and gave my peace of mind to the session. And then they thought I had done well, so that when they did a shortlisting for the JSAP Moot, which I had not even participated, I think one of the people who had been shortlisted became unwell or shied off, and I was opted as a researcher. And therefore, I had to start to think, what is this Moot actually about? And of course, I found it quite interesting, and that was my journey into it. So I participated in the Moot up to the national, to the regional level. Suffice it to say, of course, we didn't win. The people who won became runners-up in the international competition itself. And from there, I had a certificate, which when I wanted an internship, I went to an organization and, of course, told them I have an interest in human rights. And to evidence my interest, I have actually participated in the JSAP and these other moots. And therefore, I think I deserve a position to learn with you. And them having looked at those qualifications gave me an opportunity to intern with them. After that, when I wanted to do a master's degree, I sought for a position, a vacancy. And I needed to be sponsored because I didn't have the finances to do so. So I again presented my certificates, and one of the critical ones was that I had participated in the JSAP Moot, and I think they looked favorably in my participation, and therefore gave me a full scholarship. A full scholarship implies they gave me an air ticket to the university, an air ticket for holiday during the mid of the program, and sustenance for the 2 years period I was to do my master's, plus a full capitation for the program. So I had to just take myself to the airport and also bring myself back from the airport. I'm saying this because I want you to look at the value that mooting can bring to your career. In fact, when I was doing my master's, I came to realize that most of the people that were taken for that program in the same manner, with the same scholarship that I had, were very senior public officials in their respective countries. We had a Malawian who was, I think, deputy director of public prosecutions. There was a lecturer from South Africa University of Pretoria. There was a lecturer from Kampala, Makerere. There was a senior foreign affairs official from Ethiopia, and I think the other one was from Zambia, again very senior in the civil service there. So I realized that when you want to succeed in life, you need something to show. And part of the participation in which you have undertaken is that evidence. And I can tell you of other persons who have done very well, some professors, including even deans in universities, who started their student life that ushered them into a career on the basis of mooting. So for me, the event that you have gone through, the papers that you have prepared that will be published, is part of your career establishment. And therefore, I seek to congratulate you more sincerely, and hope that this will be a beginning of greater things that you are going to do. For those who are going to win, congratulations for a well-deserved win. For those who have not won, you are also a winner, because you have at least an idea that, like myself, who may not have won the JESAP, just by participation, it will definitely open doors for you. I want to take this opportunity to also really thank and congratulate the Dean of the School of Law. I know that the titles have changed with the new changes in university establishments, but the fact that you have been able to sustain this program, which was started, I think it's more than 12 years ago, if I'm not wrong. It was in 2012, because at that time I was already teaching as an adjunct faculty at this school because I started off here in 2011, and I have seen it grow. In fact, the fear that we have when we are given opportunities is you come and there are established programs, and there are ways in which you must sustain them. Otherwise, then it will collapse on your hands. The fact that you've been able to uphold this mooting competition for the duration that it has taken is an evidence of your ability as a leader and as a motivator, and I'm looking forward to continuous growth in this process. On behalf of the National Council for Law Reporting, where I serve, I want to promise of our continued support and assistance to ensure that this program continues to soar into greater heights in future, so that in future there will be even bigger events that would not just be limited to national moots. You see the way South Africa has their international moots, they have competed. There's nothing that prevents us as a country from having those competitions that are one in a lifetime opportunity for law students from across the world. I know, like, the JESAP also includes participants from the postgraduate level, and as we grow our postgraduate program in the diverse universities, perhaps that's an area of growth that we must consider when we want to grow this mooting program. With those very many remarks, I want to thank you for the invitation for me to be with you on this auspicious occasion. I thank you.
Thank you so much, Professor Jack Wimali. Let's give him another round of applause. Now, I just want you to turn to your neighbor, I love using this, and tell them the moment that you have all been waiting for is here. Are you ready to know who are going to win? Okay. We're going to start with the awards for the research category. And to take us through the awards for the research category, I'm going to invite Stephen Kamara together with Kelvin Kimani to give these results, and Hamisi. Let's give them a round of applause as they come. Now, I know as a human rights competition, you might wonder, okay, what's the gender equality? But the ladies are reigning in the Moot category, and you'll see them as they come. So let's appreciate the gentlemen as they take us through the research category.
Good afternoon, everyone. As Daniel has so vehemently introduced me, my name is Stephen Kamara, Deputy Head of Research. And drum rolls, please. But first, we'll start with overall the best research papers. In no particular order: Team 1226, Makofi; 1213, 1215, 1218, 1217, 1205, and 1220. On to the best presentations. Now, yeah, of course, the teams that I've announced, they should stand so that the audience can properly appreciate them. Thank you. Now on to the best presentations. No particular order: Team 1206, please stand. Team 1213, Team 1226, Team 1217, 1209, 1218, 1205, and 1220. A round of applause. Now, on to the best presentation. And I would like Mr. Hamisi to announce the best presentation.
Okay, so for the best presentation in the research category, we have Team 1206. A round of applause. So, yeah, Team 1206. Congratulations for that. Okay, so we'll call you to the front so that you get an award for, being the best presenter. And to award her, I'll call upon Mr. Griffin Lumbasi, who is a judge at the research category, to award her. Sorry. A round of applause as we wait for... A round of applause as she's awarded a photo. I think you can come to the podium so that we get a good photo. On to the second runners-up, we have a team or a participant who got a mean of 85.5. You can clap, kindly clap. In the research paper, the person got 85.5, and in the presentation, they got a mark of 85.5. So this second runners up is, drum rolls, team 1217. So for this award, I think we'll call Dr. Tom Ratemo, the deputy executive dean, to award him. Okay, for the first runners-up, I'll call upon my colleague, Mr. Kimani Njenga, Mr. Kimani Kelvin, to
mention the name and the school. Mention the name and the school.
Don't have the school. Okay, so I'll call upon Mr. Kelvin Kimani to, announce the first runners-up. Kimani.
Good afternoon. My good name is Kelvin Kimani, or KK. And on to the second runners-up in the research category. First runners-up, in the research category. The person got 86 in total, that is the average. And in the research paper, he or she scored 87 points, and on the oral presentations scored 85. And the first runners-up for the research category in the 12th edition of the All Kenyan Moot Court competition is, drum rolls, team 1205 from Africa Nazarene. Loud of applause. She deserves better. She really did well. And the person to award her is none other than our former dean, Dr. Kabata. Clap for her.
So a round of applause as she's awarded. Just to mention, the student is from Daystar University.
Abigail Omondi.
And now for the, yes, okay. Now for the moment we've all been waiting for, the winner of the research category with an average mean of 88.25. In the research paper they got 84.5, presentation they got 92. Drum rolls please. And the winner of the research category of the All Kenyan Moot Court Competition, 12th edition, is team 1220. Kenyatta University, and the name is Brian Naimodu. To award this prize is Professor Jack Mwimali. Professor Jack Mwimali shall award this prize. Prof. Makofi tena. The university is Kenyatta University. And we'd like to call Team 17, Team 1217, and Team 1205 to come for a trophy. That's Daystar University and Africa Nazarene. Clap for them as they come to the stage. And I'll invite the representative from Uraya to Mr. Alois to take a photo with them and award the trophies. Makofi tena. A photo? A photo?
Can have a photo. Thank you so much. So from the research category, we would like to encourage more of you to write papers which are going to be included in the e-journal. So we are expecting more papers in the 13th edition, right? Okay, thank you.
Thank you.
Well done to the best researchers. Let's give them a round of applause. So at this time, I'm going to invite Faith Mahinda and Bani Swangeshi, who are going to take us through the memorials course and the oral rounds for the Moot category, which I know we have all been waiting for. Let's give them a round of applause as they come. Yes?
So good afternoon. Good afternoon once again. My name is Bani Swangeshi. I'm the deputy head of the Moot category. I'll let my team members also introduce themselves. However, first of all, before I begin, receive greetings and apologies from the head of the Moot category, Michelle Kakai. She's away, but she's coming. So first of all, I'll let my team members also introduce themselves.
Good afternoon, ladies and gentlemen. My name is Jeremy Nyoike, and I'm a member of the Moot category. Pleasure.
Good afternoon. My name is Faith Mahinda. As I was earlier introduced by Mr. Murakaru, I equally serve as deputy head of Moot category.
So I'm sure we are all really anxious, so we will be very brief, very brief. So we have divided ourselves into 3 separate awarding sections. Mahinda will announce the oralists, then Jeremy will do the memorial awards, and then I will do the biggest one for the best teams. So at this point, I'll invite Jeremy.
Thank you so much. It's now my pleasure to announce the best memorial teams, and we're going to start with the best applicants, memorials. Drum rolls, please. The best applicant memorial with a score of 89.5, team 1215 from Embu University. For this award, I would like to call Miss Rispa Odanga, kindly, please, if she's present. Oh, okay. Okay. Going on to the best respondent memorials. Drum rolls. With a score of 83.5, again, team 1215 from Embu University. A round of applause, please. Thank you so much. Thank you. You can sit. You can have a seat. And so, therefore, the overall best memorials, after analyzing from hundreds of memorials submitted, with an average of 86.5, drum rolls. Team 1215, again from Embu University. Congratulations. I would like to invite the Dr. Tom Ratemo, kindly, please, award. A round of applause for them. Thank you so much. That's it from the Memorial Awards. Let me invite Faith to continue.
Hi. So, personally as a Moot, I have always wished to get an oralist award. Now, unfortunately, I have completed my mooting career without that happening. However, it is my... Okay, fine. We will reconsider. Anyway, well, it is my absolute honor to be announcing the best oralists. And for this, I will invite our former dean and a very integral person for the success of countless editions of the All Kenyan Moot Court competition, Dr. Faith Kabata, to issue these awards. So, best female oralist, drum rolls. We have Miss Jardine Egwa from Team 1211, University of Nairobi, Parklands. Okay, in absentia, okay. Hi, do we have a representative from the University of Nairobi? Please come on. Hiya, and her counterpart in the male category is Mr. Herbert Wanyeki from the same university. So I will request, Dr. Kabata, kindly remain on stage. So I will request that, Do we have a male representative from the University of Nairobi? Thank you. Please come on stage. Makofi. Oh, we may have the two representatives leave the stage. Now, for the next 2 awards that we will be announcing, these are specifically selected from the finals category. I'm sure those of us who went to the Supreme Court witnessed the excellent submissions and the excellent quality of oratory skills that were exhibited. And so, the best oralist from the final rounds of the All Kenyan Moot Court Competition 12th edition, drum rolls, is none other than Simon Mureithi. Yes, continue. Yes. Mr. Simon Mureithi from Kenyatta University. And our final award. Now this we introduced in the last edition. Because we noted that there are exceptional students, but then, you can only have one best final rounds oralist. So our best overall student, also selected from the final rounds of the competition, we have none other than Miss Naomi Kadhambi. It's okay. So makofi for Miss Naomi Kadhambi from African Nazarene University. So, thank you so much, Dr. Kabata, and congratulations to all the oralists awarded. Makofi again. And now, at this time, I will invite my fellow deputy head of Moot category to, announce what you have all been waiting for since we began the competition officially.
Good afternoon again. Good afternoon. I'm back here for the big award. So to increase the anxiety, I will start with the second runners-up team, and then they will be awarded. So the second runners-up team, drum rolls please. We have team 1220 from Kenyatta University. For this award, I will invite Professor Thomas Millet. Please come and award the team.
Congratulations.
Congratulations.
I think you may go.
Sorry, no. I have experience only receiving awards and not giving.
So, now for the moment you've all been waiting for. So, for the moment you've all been waiting for, the first runners-up team of the 12th edition of the All Kenyan Moot Court competition. Drum rolls, please. We have Team 1206, Team 1206, Kenyatta University. So Team 1206, Team 1206 had an average of 79.167. Clap for them, clap.
Congratulations. Be proud of this medal. It will bring you a lot of luck and happiness in your life. Very proud of you.
Professor Thomas, you may take a seat. Yes. Now, for the best team of the 12th edition of the All Kenyan Moot Court competition, I'm sure we are all aware of this team, so I won't say drum rolls. Team number 1204, African Nazarene University. For this award, I'll invite Professor Jack Mwimali to give the award.
Congratulations, Africa Nazarene. A round of applause for them. As we wind up, from the Moot category, we would like to recognize the standards that have been upheld in this edition of the All Kenya Moot Court competition. And I think my fellow member forgot to announce that Africa Nazarene had a mean of 79.83, and the first runners-up had a mean of 79.167. So it was that close. And so a big congratulations to all the teams that have proceeded. We'd like to commend the standards that have been set, and in the future editions, we'd like to urge all the participants, both here and online watching, to keep on and improve the standards. That's it for the boot category. Thank you so much. Have a lovely day.
Wow. 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 Let's give it a round of applause to Africa Nazarene University. And to Kenyatta University School of Law as well. Yes. We wait for the 13th edition, isn't it? Yeah. As a Kenyatta University alma mater, next edition when they come to home ground, we beat them, isn't it? Yes. So we prepare and we go back to our drawing boards. Yeah, ndio tusipigwe nyumbani, si ndio? Yeah. Otherwise, let's give them a round of applause. Congratulations once again. So at this particular moment, I'm going to invite the president of the All Kenyan Moot Court Competition, 12th edition, Mr. Kimani Njenga, who is going to award the partners and also give the Spirit of the Moot Award. Let's give him a round of applause as he comes.
Good afternoon, everyone. How are you all doing? So congratulations to the team that has won Africa Nazarene University. Last year they were first runners-up. This year they came determined to win. So congratulations. 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 Congratulations to Kenyatta University. Job well done. Job well done. It was such a close call, like you've seen from the results. But either way, we always have to have one team. So you did a good job, whether or not you've received an award. One thing we do for All Kenya is that we try and make sure that students get a very nice experience. They learn so much while at it. They interact with real issues from the moot question. So my plea to all of you is to become advocates of change in whatever you do and continue growing your mooting careers. So at this juncture, I'll just want to highlight a few things with respect to the standards of the competition that we upheld this year. For starters, in terms of research, we have noticed with growing concern that the quality of research papers that are being written by our students is not at its best. The quality is going down every year, every year. We also have serious issues with plagiarism levels from the research that students are publishing. Plagiarism is a very serious academic offense, and this year we had to disqualify some teams on account of plagiarism. So please, moving forward, let us eradicate plagiarism, let us produce original work, because we cannot have students plagiarizing research papers. All right? So that is a tradition that started in the 11th edition, and we are going to maintain it. We maintained it in the 12th, and moving forward, we are going to maintain that aspect. So let us produce original work in our research papers. Another aspect is the e-journal. The deadline for receiving papers for the e-journal is today. I hope you're all sending them. We'll be reviewing them, expert review, and then publish sometime later in the year. So let us, we've noticed lawyers don't like researching and publishing work, but we want to create a culture where students can be passionate about research and publishing, even scholarly articles. It grows your profession. Lastly, is to thank our esteemed partners. Most of them are not in here today, but for the ones who are present, we'll definitely be sure to give an award, and for the rest, we'll deliver physically as we meet with them. So our first partner, who we are going to give an award this afternoon, is the National Council for Law Reporting. And I must say that Kenya Law has been one of our loyal partners that we've had for the 12 years that this competition has existed. Their support is usually very instrumental in terms of research. They give us judges for the competition. They help us with constitutions. So I would like to invite Professor Jack Mimali to receive an award from the All Kenyan Moot Court Competition. It's an award of appreciation. And I will request one steering committee member, and that is Charles Juma, to give these awards to the National Council on our behalf. Thank you so much, Professor. Thank you so much, Professor, and we hope to continue partnering with your good organization. The next partner who is present is Uraia Trust. I'm not seeing their banner, but Uraia Trust is very passionate about civic engagement and the work that students do. They are also our key partners. I think this is the second time we are working together, and we've had a very successful partnership, which we hope to grow over the years. So this is to thank you, Mr. Alois, for agreeing to partner with us and for giving the students a very easy time in terms of even the proposals and everything. And giving these awards, I'll invite our communications director, Fleria, to give this award on behalf of the steering committee members to Uraia Trust. Thank you so much. Thank you so much. Thank you so much. And may God bless Uraia Trust. All right. At this juncture, I want to introduce the members of the steering committee, to whom without their hard work, sacrifice, determination, will not have had this week. So please, members of the steering committee, step forward. I want to introduce each and every one of you, and as well as appreciate all of you for the job well done. Please, please, Hamisi, all of you, just come forward. So this, ladies and gentlemen, are students. AKMCC is a student-led competition, and amidst their busy schedules, they find time to organize for this moot court. And the preparation for this takes well over a year. So it takes a lot of hard work, determination, preparation. So thank you so much. I'll begin from the farthest right. This gentleman is called Jeremy Nyoike. He has been, he's joined the committee for the first time this year. He's in second year, and he works in the moot court category. So let us appreciate Jeremy Nyoike. Next to him is Faith Mahinda, equally joined the committee this year and has done incredibly good work. She's the deputy head of moot category. Let us appreciate her. Next, we have Bani Swangeshi. This is her second time in the committee. She's also a deputy head of moot category. Let us equally appreciate her. And the boss of the moot court category apparently is not able to join us. Her name is Michelle Kakai. She has served as the head of moot for 2 years in a row and a deputy head of moot. She's currently involved in a moot court as well, the John H. Jackson, which is having its all arounds today. So in absentia, let us appreciate Michelle Kakai. Next we have Thomas Hamisi, the students coordinator, a very important docket. I'm sure for most of you, he has been your contact person in terms of the logistics and everything. He has equally done a very good job. So asante sana Hamisi. Let us appreciate him. Tusichoke kupiga makofi. All right. Next we have Kevin Kemani. Kevin Kemani Gazua. He's our organizing secretary, also in charge of logistics. Let us appreciate Kevin Kemani. Next, we have the man with the money. This is a docket I previously held. So we have Charles Juma. Let us appreciate him. Yes, it's a very important docket. Next to Charles, we have Fleria Catherine, our communications director. Please appreciate her. And lastly, a very important person is Brenda Owiti. This week she has been really up and down, but for good reasons. She's the conference director. Let us appreciate Brenda. She has been the one in charge of your lunch, in charge of conference, in charge of these goodies that you're all going to receive on behalf of Kenya Moot Court. So thank you so much. And now, these ladies and gentlemen also don't work alone. We receive a lot of support. There's one arriving late. All right, a gentleman who has just come in. Let us also appreciate him. His name is Stephen Kamara. He's the Deputy Head of Research. And the Head of Research is also involved in a moot, and she's unable to join us today. Her name is Martha Jepkemei. Let us also appreciate her. Asanteni sana. So now, these ladies and gentlemen have enjoyed the support of the university, have enjoyed the support of key partners, and just to appreciate, we like to, first of all, we have an award for two very important people who have helped us. One is the school for providing us with an opportunity to host this, for helping us with the logistical support. So we have an award, and maybe you could help. We have an award for Dr. Tom Ratemo, our Deputy Executive Dean, for helping us with the logistics. So, yes. So this award is given by all of us to Dr. Tom Ratemo. So we can all gather together. They're not there. They're so distant. Can you hear me? The next award is called the Spirit of the Moot Award. Oh, before we go to the Spirit of the Moot Award, we forgot to award another important partner, which is Kenyatta University. And I will request also Dr. Tom Ratemo to receive the gifts on behalf of Kenyatta University. Yes. And now, to a very important award. It's called the Spirit of the Moot Award. This one is usually a surprise. Even the person who is going to receive it does not know that they are going to receive this award. This person, I don't want to refer to gender because it will leak the surprise, but this person has been very, very instrumental in organizing the moot court, in helping the students organize for this moot court. Not just this edition alone, but in very, very, very many editions. In terms of thinking, in terms of helping us get partners, in terms of helping us with the support. This award, Spirit of the Moot, we just give it to them to recognize their efforts for helping the students and for helping prepare the moot court. This award goes to none other than Professor Thomas Mile. Yes. Let us clap for Professor Thomas.
Yes, I will hug now. Give a short hug. Because I know all those people here. Hey. I need to go to FC. Wow.
Thank you so
I'm
much.
really very, very humbled, yeah. Thank you so much. This is a very special award for me. I would like to thank you, and I'm quite speechless. Thank you so much.
Thank you. Oh. Thank you so much, Professor. We appreciate the hard work that you've always supported the Moot Court competition in the so many years that you've been in this school. I can't even count. Thank you so much. All right, ladies and gentlemen, I think we have come to the end of the 12th edition of the All Kenyan Moot Court. It's a very bitter, sweet moment for me. But yeah, I want to thank all of you, most especially. There are people I have forgotten to acknowledge. Yes, and this is so bad of us. We have the people seated on the right. They are donned in very beautiful white t-shirts. These are our bailiffs and our rapporteurs who've been helping us with the coordination. Let us clap for them. Thank you so much. They're equally students, and this year we've had very nice, very good bailiffs, very good rapporteurs, very cooperative, very supportive. We've not had any challenges with any of them. So thank you so much. Thank you so much, and may God bless you. All right. So now, oh, yes, I'm being reminded, forgive my manners. We have the technical team, especially the people who've been helping us with the sound, the support staff of Kenyatta University for helping us with the coordination. I have just seen Momanyi walk around. Momanyi is a very integral part of this competition. So collectively, let us appreciate the technical work that they do to help the students organize for this. Thank you. Thank you, thank you, thank you very much. And also the presidents of the previous edition. I have enjoyed a lot of support from the president of the 11th edition. She couldn't make it to be here with us, but also in absentia, let us also appreciate her. Her name is Karemi Janet. All right. We have come to the end of the 12th edition. So thank you so much for helping us make this a reality. And I urge you to preach a good word about the competition out there. So now, to celebrate the end of the 12th edition, we have a very beautiful cake in front of us, which we are going to cut together with our partners and students, share the cake amongst ourselves before we head out for lunch. And then thereafter, students and our guests can leave at their own pleasure. For those traveling outside Nairobi, and for those we accommodated at Hennessy's, I hope you had a good time. I hope you enjoyed the buffets. I hope you enjoyed the, the nice things that we had. Okay, it is in Ngara, but those of us who've stayed there can attest to the quality of the experiences that we've had. So now, I think Brenda should guide us with the cake cutting. We're going to all gather down here, cut cake, and then we're going to help with the distribution. Please make sure you get a piece of cake before you go. Oh, I forgot to mention another steering committee member. I don't think she was in. Please wave. Her name is Shajoy Wandera, the Deputy Conference Director. All right. So now, let us all gather down here and together cut cake. Have you taken photos of the cake before we cut it? All right. I request Professor Thomas, Professor Mwimali, Dr. Atemo, Moya Lois, everyone seated at the front row, Griffins, to help us with the cake cutting.
ahe. Tamu tamu tamu, keki ni tamu, ahe. Oh, tamu tamu tamu, keki ni tamu, ahe. Tamu tamu tamu, keki ni tamu, ahe. Sweet sweet sweet, keki ni sweet, ahe. Sweet sweet sweet, keki ni sweet, ahe. Oh, sweet sweet sweet, keki ni sweet, ahe. Sweet sweet sweet, keki ni sweet, ahe. Tufurahi sote tukiingoja, ahe. Tufurahi sote tukiingoja, ahe. Oh, tufurahi sote tukiingoja, ahe. Yeah. Tufurahi sote tukiingoja, ahe. Tuna meza mate tunaingoja, ahe. Tuna meza mate tunaingoja, ahe. Oh, tuna meza mate tunaingoja, ahe. Yeah. Tuna meza mate tunaingoja, ahe. Tamu tamu tamu, keki ni tamu, ahe. Tamu tamu tamu, keki ni tamu, ahe. Tamu tamu tamu, keki ni tamu, ahe. Keki ni tamu.